When you hear people talk about custody, custody means different things. There's physical custody. That's the custodial timeshare and usually what people are talking about. A custodial schedule for physical custody could look like week on, week off, a split week with 3 days to one parent and 4 days to the other. Or a 2-2-5, where one parent has Monday, Tuesday, the other parent has Wednesday, Thursday, then they alternate Friday, Saturday, Sunday. That's a physical custody arrangement, and those are joint custody arrangements. There's also primary physical custody, where one parent has more than 60% of the time. But then there's legal custody. Legal custody involves things like school choice, religious beliefs, and medical decisions. Legal custody is usually joint in Nevada, meaning both parents have the ability and the right to make decisions together regarding the children's upbringing. And if they can't decide, they have to have a tiebreaker. Oftentimes, that tiebreaker is the court. We've had cases where we've gone in front of the judge and advocated for our clients because the parents couldn't agree on what was best for the children. The good news, when you get to court, whether it's a legal custody issue or a physical custody issue, the law requires the judges to make a decision that's in the best interest of the children. Judges are likely to look for ways to keep joint legal custody because they really don't want to take away a parent's right to make decisions regarding their child's upbringing. If you run into an issue with legal custody and decision-making, it's important that you get legal assistance because we can go in front of a judge and explain that you should have decision-making power over one area or one issue so that your child doesn't suffer because you can't agree on what's best for them regarding those decisions. With physical custody, it's a little bit different. The best interest factors are still considered, but those best interest factors are then looking at who's going to be able to take care of the child, who's mentally and physically able to care for the child, and can both parents or one parent meet the needs of the child, both educationally, developmentally, emotionally. The courts are looking to make sure that the kids are loved by both parents and that the kids have the opportunity to feel that love from both parents. And so they're going to look to see, can you guys work together? Are you guys able to do it together? Can you both provide for them? And how well do you navigate the challenges that come with sharing custody? Custody orders are never permanent. Until your child is 18 and is no longer under an order from the court regarding who has custody, the custody orders can always be changed. The requirement to get in front of a judge on a modification of custody is a substantial change in circumstances or a significant change in circumstances, meaning that something is different now than it was when the court entered the order. Things that can change would be job schedules or employment, maybe a relocation opportunity. Maybe there's something that the child needs that's not being met in one parent's home. One parent may move away from the school where the child was attending and it's no longer convenient. There are so many things that can happen during a child's life, especially when parents get divorced when the child is young. And then they have to navigate all of the school and educational things that occur while the child is still under that custody order. If you're curious about whether or not your change is significant enough, give us a call. We're happy to help you navigate that issue. We will advise you on whether this change is significant enough in our opinion, and if it is, we'll help you get in front of the judge so you can plead your case. Relocation is one of the most difficult requests when you're asking another parent to let you move out of state with their child. If you have primary physical custody and the child is with you most of the time, it's significantly easier to get the judge to agree to let you move out of state. The standard in those situations is that it must be in the child's best interest to let you relocate. There are a lot of factors, and it's a hard burden, but you can move out of state. You just have to get the court's permission before you go. Don't leave without your child. And don't take your child until you either have the other parent's permission or the court's permission. Relocation is one of the most challenged custody issues. It's really hard sometimes to reach an agreement, especially if you have joint physical custody, where the other parent has 50% of the time and you're drastically decreasing their custodial time with your relocation. It is important that you seek legal assistance for a relocation case because the standard and burden is on the person who's looking to move, which means you have to show that it's in your child's best interest to let you relocate.